go.
Where's the 20th?
Let me try this again.
Tell
I'm
us
Amira Fox, the state attorney in the 20th Circuit.
Where is that?
That is Southwest Florida. We have Lee, Collier, Charlotte, Hendry, and Glades counties. Huge circuit. I'm also here on behalf of the Florida Prosecuting Attorneys Association. I am the vice president for the association. We're here to speak in support of what we consider to be a great bill. What we believe was unintended consequence of the statute passed last year was that when January hit and we started to have pretrial detention hearings, which are now required for not only capital and life felonies, which were already required, but also for first-degree felonies. There's a list of those dangerous crimes that you just heard Senator Bradley talk about, that the intent, I don't believe, of the legislature was to make us call victims people who are in the hospital, children who have been abused. The intent was not that, I believe. So to fix that, because the statute that went into effect in January says that we must have a pretrial mandatory detention hearing, not only on life and capital, but on first-degree felonies also. What this does is it fixes that for first-degree felonies. The Florida Rules of Criminal Procedure allow us to rely exclusively on hearsay in capital and life felonies, but they do not allow us, funnily enough, to rely exclusively on hearsay in first-degree felonies. What this does is it fixes that. So it'll stop us from having to call, and the result of this, we are having to call children, people who are in the hospital, people who've been awfully victimized. These are the worst of the worst, as Senator Bradley said. We're having to call them to keep somebody in custody on a pretrial detention hearing. That could not have been the intent of this law, and we're in great support of this as a fix to that. And we ask you to please pass this today.
Mr. Chair.
Any questions?
Mr. Chair.
Yes, Senator Powell.
Thank you. And thank you for clarification. I'm not an expert on this, but I do have a question
Sure.
that I want to get to. This standard of beyond a reasonable doubt and the idea of proving something beyond a reasonable doubt, but changing to allow someone to be held in pretrial detention based solely on hearsay testimony. I'm questioning that. Can you balance the two? Can you show me, or can you explain to me how that works, that you have the standard of beyond a reasonable doubt, and then to be able to hold somebody based on hearsay?
So, again, this is going to be, I'm sorry, thank you. This is going to be up to the judiciary to determine whether they think the state has shown beyond a reasonable doubt that the person should be held in pretrial detention. What this does is it allows a judge to let us rely exclusively on hearsay, but it also gives the judge the ability to say no if they don't think the state has reached their burden, as I think has been pointed out earlier by a couple of the senators. Absolutely, the judge would be able to say, state, you have not met your burden. I let you rely exclusively on hearsay, but you haven't met your burden by doing it that way. So that balances that out. And it does give the judiciary the ability to say no on pretrial detention and turn it into a bond hearing where they set a bond. Thank you.
Follow up? Senator Pizzo.
Thank you. Madam State Attorney, I think you were here last week when we had a different setting on this bill, different committee meeting. In light of last year's HB 667, which actually changed basically the model and the availability for depositions, I had made the assertion when I was prosecutor, things have changed, that I would tell a victim they likely should expect to only have to speak 3 times. Right?
Yes.
Perhaps when they give their statement, but certainly a deposition, maybe a trial, and obviously when they give a statement, affidavit, sworn statement, whatever. In light of last year's, don't you agree that in a lot of cases we've taken away the right of depositions?
State Attorney.
Thank you. Yes, there was, I think, a great law put into place last year that protects certain classes of victims from having to have their deposition taken without the permission of a judge. And that certainly has limited the deposition and depositionability, and in my opinion, the abuse of deposition on young children. Very, very difficult and traumatizing for them. So yes, I believe we have limited depositions for certain classes of victims, but I think we did so appropriately.
And follow-up?
Yes, follow up?
And those same class of victims would now not have to give direct testimony at a pretrial detention hearing, right?
State Attorney?
Thank you. Yes, Senator Pizzo, I think that's exactly right.
Follow up?
Yes.
The only time a victim would have to confront the defendant or the defendant would have an opportunity to directly confront the accuser is actually after they've been criminally charged and they're in trial, right?
State Attorney?
Yes, so that relies on a couple of assumptions. The first one being that it does fit into the categories of depositions that you have to have a judge permission to take. That relies on assuming that the judge has said you cannot take the deposition. And it also relies on assuming that we thought we could go forward in the pretrial detention hearing without the victim and just relying exclusively, for instance, on a CPT video, which would be hearsay. If all those things occurred, then it could be possible that that would be the first time the defendant would confront the victim, would be in a jury trial.
And one last. And what percentage of your cases in your office close by plea instead of trial?
Go ahead.
Senator, it's a very high number. It's probably upwards of 95% resolved by plea as opposed to jury trial, even though we do probably 1,000 jury trials a year in our circuit at least.
Thank you.
Thank you for your testimony. Anyone else?
Thank you very much.
We're really honored today to have several state attorneys here, and I'd like them to stand because, as you know, many of these gentlemen and ladies do incredible work, difficult work,